Meeting will come to order. For those in the audience, welcome to Federal and State Affairs. I need to ask my webmaster here, are we on? We're on. Good. Things will work smoothly today. I was born an optimist. We are on a typed schedule. I'm not going to do bill introductions. If we have time at the end, I will do bill introductions. Committee members, when you ask questions, the first thing you need to do is state your name. That way the camera moves to you. You can either say, this is Representative so-and-so, and my question is, and by that time, you will be on camera. We have a strict schedule. As you all know, I announced yesterday, each side will get 32 minutes. There'll be about 13 minutes for questioning. And then I will close the hearing. Committee will take up House Concurrent Resolution 5003. With that, Matt, you're on, the Revisor's Office, if you'll give us an overview.
Thank you, Mr. Chairman, and good morning, committee. Hopefully, my memo for HCR 5003 has been distributed to the committee. I want to briefly walk the committee through some of the procedural aspects of the resolution so that you can quickly get to the policy discussion with the conferees. So my memo, House Concurrent Resolution 5003, would amend the Bill of Rights of the Constitution of Kansas by adding a new section to the Bill of Rights regarding the regulation of abortion. The new section would state that nothing in the state constitution requires the government to fund abortion, and it does not create or secure a right to abortion. This new section of the Constitution would also provide that the people of Kansas, through their elected state legislators, may pass laws regarding abortion. Such laws would remain subject to the United States Constitution's protections of an individual's right to abortion. Procedurally, as with all concurrent resolutions proposing amendments to the Kansas Constitution, this resolution must be adopted by a 2/3 vote in each chamber in order to be presented to the general electorate for approval. In the case of HCR 5003, if it is adopted by this constitutional majority in both chambers, the resolution calls for a special election to be held in conjunction with the primary election on August 2nd, 2022, pursuant to Section 1 of Article 14 of the Kansas Constitution. So that's just a quick run through of the procedural aspects of the resolution. Be happy to answer any questions the committee has on that.
Thank you. Committee members? Have a copy? I'm sorry? Representative Smith.
Thank you, Mr. Chair. Thank you for that presentation. Matt, I'd ask, is there anything within this bill that would ban abortion or provide any restriction on abortion directly?
So this resolution calls just for the Kansas Constitution to explicitly say that the Kansas Constitution does not provide, does not fund abortion. It does not create or secure a right to abortion. It does not change federal law. Federal law would still apply. It simply proposes to explicitly state in the Kansas Constitution that the government does not have an obligation to fund abortion or create or secure a right to abortion.
Thank you. No further questions. I will start with the. I'm sorry.
Thank you, Mr. Chairman. Jean Gowden with Kansans for Life. I would like to ask if it's possible to have Brittany Jones with the Family Policy Alliance of Kansas come up as I have ceded my time so that she can do that until Elizabeth Kirk is back up.
I think we're back up right now. So, is Elizabeth Kirk?
Yes, I'm here.
Ms. Kirk, go forward with your testimony.
I'm sorry, can you repeat that? Can you hear me? I can hear. I don't think the chamber can hear.
Strict scrutiny is the highest form of judicial scrutiny, and almost every time it is used, a law is struck down. And so courts are very hesitant normally to use that level of scrutiny because of the fact that it has no law. And the most important point for you as legislators to note about scrutiny is that strict scrutiny takes away the deference that a judicial body will have towards any laws that we make. And in fact, it flips that deference and instead presumes that any law that you pass is presumably unconstitutional, effectively taking that power out of your hands to make legislation. But let's look at four different areas of law that are most under threat because of the housing hazard ruling. And those are laws on women's right to know and 24-hour waiting periods. Secondly, parental notification. And thirdly, clinic licensing. A pro understanding of the law. In 1997, as one of the first pro-life laws that the state of Kansas enacted in the post-Roe era, was a woman's right to know and a 24-hour waiting period. And these laws simply ensure that a woman knows who her doctor is. It ensures that she has basic information about the procedure she is about to undergo, and it gives her time to think about this procedure before she undergoes the procedure. However, as we've seen in case law across the country, in different federal courts and in state courts, these types of law are struck down when you use the level of scrutiny that our court used. It's a level of scrutiny that's not even used. The federal courts have typically said they will not use in the area of abortion because there are so many different interests. And what our court did that was so different than what other courts are doing is that they did not even consider other interests. They said the only interest that mattered was the woman's right to have an abortion. However, this does not allow for other interests that the state might have, like making sure the woman has a clinic and that she understands the procedure that's about to happen to her. So the intention of the law was to ensure that women have the ability to learn as much as possible about the procedure before she undergoes it. However, courts that use strict scrutiny do not recognize the health of the mother as a compelling state interest and have struck down informed consent laws. The second area of law that the courts have that is under threat because of the Hodes decision is parental consent laws. And in Kansas, we have a law that requires that a minor girl who is seeking an abortion gets the consent of at least one of the consent of her parents before she undergoes that procedure with a judicial bypass, as required by the Casey ruling. However, as we've seen under Roe understanding of the law, and in states that use strict scrutiny, these types of laws are struck down. At least 4 state courts have struck down parental consent or notification as violating their state constitution's right to abortion, even after the Casey decision in 1992. When courts use strict scrutiny, even when alerting a parent to the fact that their minor daughter is considering an abortion, it is seen as an infringement on this right. And after the Hodes decision, there is no reason that the same law in Kansas won't be struck down. The third area of law that's under threat is clinic licensing laws. And in Kansas, we have basic licensing laws to ensure that when a woman goes into a clinic, that there's basic safety and security things are met to ensure that it's not a dirty clinic. We do have instances in Kansas where clinics have not been safe for women, and so we want to make sure that women, when they do go into a clinic, that they are going to be receiving at least basic medical care and safe care. And so,
yeah, but I want to get the video up.
Country and in state laws that use the same level of scrutiny as our Hodes court, that these sorts of laws have been struck down, and they will likely be struck down under a Hodes ruling. The final area of law that we'll look at today that is under threat because of Hodes is the taxpayer-funded component. This was a bipartisan law that was passed by our legislature that protects taxpayer dollars from being used for abortion. And as we saw in the Hodes court case,
can I do stop video?
Majority in that case, majority in that case,
I don't know.
Actually,
You could answer
cases from other states.
Can I do stop video?
Struck down their bans on taxpayer-funded abortion because of using strict scrutiny. So they've already relied on these decisions, indicating that that is where they intend to go.
We're trying to do this
potentially one of the protections that we have in Kansas that is most at risk. So it is vital that we protect Kansas' rights to not have their tax dollars used for abortion. Because we've seen across the state that Kansans are adamantly opposed to this. And our court has already indicated this is where they're going. So that's the fourth area of law under threat. And it's valued them both will restore the power to this legislature
we don't have it on the screen. Just Google Kansas legislature.
Like to ensure that
and then go to its house.
to ensure that a woman who goes to a clinic should at least have basic health and safety standards in place. And that should be at least know where a doctor is before she walks in the room.
So what you do when you get to the Kansas
that are under
legislature
threat if the legal canals are in place. And that is why we're to pass
the House Federal and State Affairs Committee. I think that's the way you get to it. Because they're the ones that are having. And then at 11 o'clock, the Senate is supposed to send it to the judiciary. Is supposed to come back to you know. So if you go there, you probably would be able to find out how to get to it. I think. All right. Great. Yeah, although I think usually people in favor of first, so it could be a while. Yeah. They haven't even started that yet. Yeah. Okay.
I'll be your testimony.
Thank you, Chairman. I'm Director of Government Relations with Kansans for Life. In the possibility that we will not be able to hear some of our conferees through the WebEx, one particular one, Dr. Catherine Powers, I just want to direct you to her written testimony. She is an anesthesiologist. She testified last year. She spent her life advancing fetal pain management for in utero surgery on preborn babies. So she stands for those unborn babies who are subjected to live dismemberment while not anesthetized. So just to draw your attention to that. Kansans for Life, of course, is very much in support of Value Them Both Amendment. Decades of experience have shown that unlimited abortion hurts women and babies. And nowhere is that more evident than in the issue of clinic licensure, inspection, and reporting. So in my testimony, I have examples of, back in 2003, deplorable sanitation conditions at a now closed Kansas City, Kansas Abortions Affordable Clinic. These were discovered by local police who had gone to the clinic under an unrelated matter. The district attorney contacted the Kansas Board of Healing Arts and the board, while admitting they had received many complaints about abortions affordable, declined to act, claiming that no law was being broken. It took a teenage abortions affordable employee who was so horrified at the filth inside the clinic that women in the impoverished community were being subject to that she personally decided to wipe down services with rubbing alcohol. And she was frustrated. She was unaware of state governing agencies like the Board of Healing Arts and the KDHE, so she secretly took photos of the clinic that eventually became public through the intermediary actions of Kansans for Life to the Attorney General and to appropriate state house committees. But it still took the Board of Healing Arts 5 weeks before they actually did an on-site inspection and took disciplinary action. Another example would be deaths and injuries in 2005. A 19-year-old Texas teen with Down syndrome who's in her 3rd trimester of pregnancy died at a Wichita abortion clinic. She was writhing in agony in a hotel luggage cart and the abortion satellite location, a hotel, and was taken not to a hospital, but back to the abortion facility where she died from sepsis. Now, that avoidable death, as well as the death of 3 other women during abortions that decade by a then Planned Parenthood medical director, and over 50 known cases of malpractice by Kansas licensed physicians caused a public outcry. So there was voluminous testimony given. Legislators had a mandate from the people to act, and they did so by passing clinic licensing back in 2003 and 2005. It was vetoed. 2011, it became law. Unfortunately, it's been languishing in a courtroom over 9 years now. So thank you very much, and I'll stand for questions.
Thank you. Who's that? Madam Vice Chair.
Is WebEx ready, or should we move on to? Okay, since it's going right now, we'll go ahead and go to Elizabeth Kirk. She is with WebEx.
Thank you. Can everyone hear me? Can you hear me in the chamber?
Go ahead.
Okay, thank you. Chairman Barker, members of the House Committee, I'm very grateful for the opportunity to be with you again this session as you consider the value of them both amendments. My name is Elizabeth Kirk. I'm a faculty research associate at the Catholic University of America Law School. I'm also an associate scholar at the Charlotte Lozier Institute, which is the leading national scholarly institute devoted to identifying policies and practices that will protect life and serve women's health and family well-being. I've studied and written on the Kansas Supreme Court decision, Nauser versus Schmidt, and I want to share with you my grave concern about the scope and the likely impact of that decision, and also to explain why the value of them both amendment is a reasonable response to it. I know Ms. Jones went over some of this. I'm going to go into a little bit more detail. In Hodes, the court discovered a natural right to abortion in the state constitution, completely departing from long settled Kansas law. No court in 160 years had ever believed that such a right was contemplated by the text or history of the 1859 Constitution. In discovering this right and declaring it to be among Kansans' most fundamental rights, the court adopted a judicial standard of review that is so protective of abortion that it's virtually certain to both unsettle existing Kansas law and to discourage future common sense laws, resulting in a more permissive landscape in Kansas for abortion than has ever existed even under federal law. And understanding this conclusion, and in particular, understanding why it's not fear-mongering, requires a brief recap of the 2 landmark cases at the United States level, Roe versus Wade and Planned Parenthood versus Casey. Obviously, I have time constraints. I have a very detailed submitted written testimony with tons of citations and analysis, and I urge you to read that. This is necessarily brief. So Roe is the landmark case in which the U.S. Supreme Court held that laws involving a woman's decision to terminate her pregnancy implicate a federal constitutional right to privacy.
Hey there, just a minute.
And the court determined that challenged abortion laws have to be analyzed under this highest standard of review called strict scrutiny. Ms. Jones already described this, but this standard is so rigorous that it's referred to colloquially by lawyers as strict in theory, fatal in fact. The government almost always loses these cases. The Roe court acknowledged, however, that even fundamental rights are not without limit, right? You can't falsely shout fire in a crowded movie theater. So they said that in the abortion context, states have legitimate interests that grow as the pregnancy approaches term. So the court set forth this limitation on strict scrutiny, which is the trimester framework. And under that framework, during the first trimester, the Roe court said there's no interest that could ever be compelling enough to interfere with a woman's right to abortion. But more weight was given to the state as the pregnancy proceeded. So after the first trimester, states could consider maternal health, and after viability, states could further regulate and even prohibit abortion because of its interest in life and human life. In the years after Roe, because of this test, very little legislation survived the application of the test. Because maternal health wasn't even allowed to be considered in the first trimester, courts invalidated numerous first trimester clinic health and safety regulations, resulting in a bad situation, as Ms. Gowden described, for women's safety. Courts also struck laws that have today broad support among most Americans, like parental consent, informed consent requirements, and 24-hour waiting periods. A notable exception was the consistent ruling at the federal level that the right to abortion did not carry with it an affirmative public funding obligation. Almost 20 years after Roe, the court revisited it in Planned Parenthood versus Casey, and Casey affirmed the right to abortion but lowered the legal standard because they said that strict scrutiny was too strict. The court said that strict scrutiny had led to the striking down of many regulations, like a 24-hour waiting period, that in no real sense deprived the woman of the ultimate decision. The court was also concerned that under Roe, the state's legitimate interests in the early stages of pregnancy were not being given any weight. So in place of strict scrutiny, it created this new undue burden standard. They also replaced trimester with viability. And that test remains the governing test today. And under Casey and the federal level, many laws that were previously held unconstitutional under under Roe are now permissible at the federal level. Okay, so with that background, then let's turn to the Hodes decision. And I hope it'll be clear why I say that Hodes is so extreme.
Elizabeth,
First,
you have 30 seconds left.
I'm sorry, I thought I had 10 minutes.
Yes, ma'am, but WebEx wasn't working, and Brittany Jones filled in for you.
Okay.
I still
Okay.
have 5 others that need to offer testimony.
All right. So I urge you to look at my written testimony to understand the ways in which Hodes is so much more extreme than either the federal standard under Roe or Casey. And in response, what I just want to leave you with is that the value them both amendment is a very modest, reasonable response to this. All it does is remove the newfound right that Hodes Court found in the Constitution, returning Kansas law to the pre-Hodes status quo, and it returns to the legislature the ability to regulate abortion. And whether or not, wherever you are on the spectrum, Hodes went too far. Whether you're pro-life and you believe that there's no right to abortion under any circumstance, whether you're pro-choice and you believe that it should be a woman's right, but she should have her health and safety protected in seeking that choice, or whether you're somewhere in the middle, you're okay with it, but you don't like public funding, or you don't like late-term abortions of healthy infants. Wherever you are on that spectrum, Hodes went too far. And the value them both amendment is a reasonable, modest compromise to undo that and restore authority to the Kansas legislature. Thank you.
Thank you. And you'll remain on for questioning period, correct, Ms. Kirk?
Yes, I can.
Thank you. Next up is Dr. is it Pfeiffer, child psychologist. Not here. Anne Marie.
Yes, yes, I'm
Elvie?
here. I'm
Oh, I'm
here.
sorry, come up. You're on, okay, I didn't know you were on WebEx. It doesn't indicate that. Go right ahead, ma'am.
Hi, I'm Dr. Jackie Piper, and I am here to talk just a little bit about the mental health effects on abortion. And I think at first, just to know that I've been in the field for 27 years, working in multitude of different places, including state hospitals, community mental health centers that are for children, even children as young as 2 years old. We worked with them. I worked in the Division of Family Services when I went into homes where people were at very high risk for generational poverty and high risk factors such as child abuse and neglect. And more recently, and I've worked in neuropsychology for about 6 years, but more recently I'm in private practice and I work with a myriad of clients, including teens and young adults. So what I wanted to talk about today, just very briefly, is the need for parental consent and notification for teens with regard to abortion, and also just a brief review of the literature for mental health effects of abortion. So on the first topic, we as psychologists, of course, diagnose and determine that kids are prepared and ready for decisions based on their cognitive and emotional and moral development. And I know that in the past, a lot of the laws that you all have made are based on those same theories, to utilize the theories that have been there for years to tell us whether or not adolescents are prepared to make decisions on their own. And we know that adolescents are going through concrete thinking and moving into abstract thinking. We also know with a lot of the brain research that we can see that the mentalization in adolescence when problem solving is in a different part of the brain as compared to adults. So adults are much more utilizing their prefrontal cortex. So that tells us a lot about whether or not adolescents would have the ability or the competency to make these kind of decisions that would impact their life forever. We also have in psychology the need for informed consent, and we do have parents involved in that. So we would also, as psychologists, imagine that any kind of a medical procedure would require consent. And the reason why is that
30
we want
seconds
people
left.
to understand exactly what is about to happen. Finally, let me have you think about the mental health effects of abortion. The best studies to look at are the meta-analysis and the peer reviews. The best right now are the Reardon studies and the Coleman studies. This shows that over 84% of women who have had abortions have correlated mental health effects as compared to women who have not had abortions. So that says a lot for us to consider. So this continues to be more and more available as participants are willing to enter studies. It has been a difficult time getting funding. Most of the funding is given to pro-choice, and so it's difficult to find the funding to look at the longitudinal studies of mental health effects on abortion, but we certainly see that they are there. We also, as clinicians, are urged to ask in our clinical interviews if a woman has undergone an abortion. Often that will help us to see that there may be a root to her depression, anxiety, post-traumatic stress disorder, even dissociative disorders and personality
Time's
disorders
up.
are
Thank
related.
you.
Thank you.
Thank you. Next up, Anne Marie Elvie, Director, Archdiocese of Kansas City. Good morning, ma'am. You have 3 minutes.
Thank you, Chairman Barker and members of the committee. My name is Anne Marie Alvey. I am the Director of Project Rachel and Project Joseph, a post-abortion healing ministry for women and men. Thank you for this opportunity to speak in support of the Value Them Both Constitutional Amendment for Life. In our work, we primarily help women heal from a past abortion or abortions. I am here to give voice to those who don't have one in the public forum, those who can't speak up for themselves because they experience so much fear, guilt, regret, and shame for a choice they made, often decades ago. In the 2.5 years that I've been helping women, my eyes have been opened. I realize now that there are two victims in an abortion, the child and the mother, and my heart breaks for them. Women have told me I went into the clinic as one person and I came out as a totally different one. Though some might feel instant relief because of the immediate crisis being resolved, it's often temporary. Women deal with their pain by coping. They deny, repress, suppress, and rationalize their feelings and their thoughts. But a trigger can break through at any time without warning. This could be a smell, a sound, a sensation, a flashback, a dream, the anniversary date of the abortion, the due date of the baby, or even another pregnancy. All this takes a toll on women's mental health. They often experience depression, anxiety, suicidal thoughts, flashbacks, nightmares, and eating disorders. These are all symptoms of post-traumatic stress disorder. Studies show that many women self-medicate in order to cope with their pain. Alcohol use and abuse has been known to increase 110%, and marijuana use and abuse 220% for post-abortive women. Suicidal behaviors increase by 155%, and it's higher for teenagers. Sadly, women aren't told that this could happen to them as a result of their abortion, nor do many even link their symptoms to the abortion. There are many physical risks as well, including pelvic infections, hemorrhaging, blood clots, perforation of the uterus, cut or torn cervix, an incomplete abortion, of which my clients have reported, infection, and sterility. Incredibly, my clients have told me that they weren't informed of any of these possible risks of adverse consequences, physical or psychological, before their abortion. How is that informed consent? In my research, I was shocked to learn that 64% of abortions involved coercion. I checked that percentage against my clients and sadly found it to be true. Coercion can range from manipulation to violence. I was astounded to learn that the leading cause of death for pregnant women is not complications from childbirth or abortion, it is murder. Please read the rest of my testimony since I don't have time to do it all here. I would like you to consider the profound effect that abortion has physically, mentally, emotionally, and spiritually on millions of women, and making it a right.
Thank you, ma'am.
Okay, thank you.
I've got to keep us all on time. Dr. Catherine Powers, is she on WebEx? Is it working?
Hello?
Yes? Are you there?
Yes, I'm on WebEx and I just unmuted myself, so thank you. Chairman Barker and members of the committee, good morning. My name is Catherine Powers and I am testifying in support of the Value Them Both Amendment, obviously. I have been a physician for the past 37 years, specializing in anesthesiology for 28 years and hospice and palliative medicine for the past 9 years. The majority of my time as an anesthesiologist was at Children's Mercy Hospital in Kansas City, both in Missouri and Kansas. In the field of hospice and palliative medicine, I was medical director of the carousel team at Kansas City Hospice and Palliative Care, which takes care of perinatal and pediatric palliative patients and their families. Currently, I am a hospice medical director in the Metro Kansas City area. I agreed to testify for this very important amendment due to the inconsistencies and duplicity of medical and legal double standards during my entire medical career. The rules of informed consent for minors were always very stringent at Children's Mercy Hospital, requiring a parent or a guardian to sign for the procedures and surgeries unless an adolescent was declared an emancipated minor, which is defined as a young parent of a child or married under 18 years of age. This practice assures legal consent from adults who are responsible for the holistic welfare of their child's life, including physical as well as psychological risks of various procedures. The implication of the Kansas Supreme Court decision to allow young female adolescents to consent to a procedure such as an abortion without parental or guardian's consent is not standard of care in any other area of healthcare. The future consequences to the young mother who may not have parental support or knowledge are potentially devastating to a young woman's physical, emotional, and psychological health. As far as my medical career in pediatric anesthesiology, I have been expected to resuscitate premature babies at birth as well as during procedures and surgeries.
30 seconds left.
Okay. Currently, there are maternal fetal surgeries being performed at Children's Mercy Hospital for congenital abnormalities. The babies are given pain medicine to relieve the hypersensitive pain response that is detrimental to a baby's welfare. Research shows the babies greater than 18 weeks gestation have developed pain pathways. These babies feel pain and are silently crying out as they die.
Time's up. Thank you.
I will be available for questions. Thank you.
Very much. Is Dr. Jonathan Scafford on YouTube or FedEx? Not FedEx.
Yeah, can you hear me?
WebEx, sorry.
Are you able to hear me?
Please, you have 3 minutes.
Can you hear me?
We can hear you.
Okay. Chairman Barker and members of the committee, my name is Jonathan Scrafford. I am an obstetrician gynecologist practicing in Wichita, Kansas. Thank you for the opportunity to express my support for the value of them both constitutional amendment. I understand would ensure the role of legislation regarding abortion will remain in the hands of Kansas citizens and their elected representatives. As a native son of Kansas, I am fully invested in affirming the rights and dignity of every human being in this great state. Having considered a wide range of perspectives on issues related to abortion during my undergraduate education in California and my medical education and training in Minnesota, I returned to my hometown of Wichita in 2017 to serve the community that I pray I may be blessed to continue serving throughout my professional life. Modern medicine makes more and more clear over time the status of the unborn child. The mere notion of fetal surgery in the womb affirms the role of the unborn child as patient. Ever-extending frontiers in gestational ages at which premature babies can survive outside the womb show the true value of what may have been mistaken merely for potential previously. Nevertheless, these advances merely emphasize that which we know of ourselves, that every human being is to be treated with dignity, regardless of his or her stage of development. About 2 years ago, the Kansas Supreme Court interpreted a virtually absolute right to abortion from our state's constitution. This right allows some members of our society, those of us who have been born, to end the lives of those most vulnerable in our society, those who have not yet been born. The field of medicine offers no objective criteria by which to separate living human beings deserving of rights from those undeserving of rights. It is thus deeply distressing to me as a physician to see that the so-called right to abortion does exactly that, to divide living human beings on the basis of their stage of development into classes with different fundamental rights. Such a right flies in the face of science and my own clinical experience. A woman's right to determine what she does with her own body should be respected for her entire life, not only the portion of her life after she is born. I am fully aware that the issue of abortion is highly emotional on an individual level and in the public square at large. So how can we resolve contrasting viewpoints on an issue so fundamentally important to whether the right to one's own body begins before or after she is born? The Value Them Both Amendment proposed today would restore the rightful role. Sorry?
30 seconds left.
Okay. This amendment would restore the rightful role of the people of Kansas and their elected representatives to guide public policy on such questions. I support such an initiative. It gives citizens a voice in this contentious debate, providing them an opportunity to protect the most vulnerable members of our society. As a physician dedicated to women's health in my home state of Kansas, I firmly believe that every woman in this great state has a right to her body, even when she is still in the womb. Thank you for the opportunity for all your work for the people of Kansas.
Thank you, Doctor. Next up is Maria Cangini. Come up. You have 2 minutes. Good morning and welcome to Federal and State Affairs.
Thank you. It's Cangiani. Thank
You
you.
should know that. I lived in Italy for a number of years.
Okay.
Thank you.
Chairman Barker and members of the committee, thank you for having me today, giving us an opportunity to stand today in support of Value Them Both Amendment for Life. I am employed in healthcare for almost 15 years and 9 years as a family nurse practitioner. I've worked with various types of peoples, ages, ethnic backgrounds, sexual orientation, religions, and values. My professional experience is in many settings, and I'm here to share my story with you today. While my life has been blessed with a wonderful husband and children and my work in healthcare, I have been on a long journey of pain and healing because I experienced when I was still a child myself, sexual assault and an abortion. I want to be sure that mothers experiencing pregnancy in a profoundly tragic and difficult circumstance have protections I did not. I am here today to defend Value Them Both. I spent my childhood striving to please my parents, who were both deaf, and my sister as well. I got good grades in school and played high school and club volleyball. I was not popular, and so when I got invited to a football party, I naturally was excited, and as a teenager, that was the best news that I could receive. Upon getting there, there was large and crowdy types of people. Being so young and inexperienced, when I was asked to join a party game with some of the football players, I did not realize what was happening. I was sexually assaulted by multiple people, and when it was all over, I was told by the girl who brought me to the party that it was my fault and to keep quiet about the whole thing so no one would get in trouble. The boys' careers were at stake, and we needed them to win the state championship and not to ruin their chances for a college scholarship. Sometime after I was injured in volleyball, I had to take a pregnancy test. Prior to an x-ray, the doctor came back and told me that I was pregnant. 10 seconds left? Okay. More or less, I am asking you guys to consider, when I went to Planned Parenthood, it wasn't a very straightforward process. It was a transaction. I wasn't given any information, more of an in and out. They never asked me about assault or referred me to counseling. They didn't try to find out if I was in danger of being assaulted again. They didn't tell me to take some time to decide what was best for me. I believe that every woman has a right to be fully informed about the elements of abortion. Without Value Them Both, the abortion industry will not be required to give accurate information about fetal development or the side effects of, or who is going to perform the abortion. Because as a victim, I am deeply pained that every time I hear a politician talk about pregnancies resulting from an assault and assuming that all women they want is to abort the baby. Victims have the right to information and the need to support so they can make the decision is best for the whole.
Thank you. You're taking other folks' time. Thank you. Danette? Is Danette here?
Yes, I'm here.
WebEx? Are you on
Yes.
the WebEx?
Yes.
You have 2 minutes.
Chairman Barker, members of the committee, my name is Danette, and I chose to have an abortion many years ago. I'd like to share with you how that choice affected me. Thank you for this opportunity to speak to you in support of the Value Them Both constitutional amendment for life. I was approached and asked if I'd share my experiences over the course of the last 37 years related to exercising my right to have an abortion. I stand here before you because it is only by sharing my choices and their impact can anyone see the lingering effects that no one can really know without living it. My only concern is that words are not strong enough to convey the aftermath of a choice that was supposed to fix something. I have to believe if someone had spoken out and been placed in my path, I might have made a different decision. When I had my abortion, I had no idea what I was entering into, nor the change in me that would take place and reside hidden for many years to come. I remember leaving out the back door after my procedure. It was sunny, the sky had no clouds, and I felt dead inside. I was married, and the abortion would have been my third child. I should have known better, but I didn't. Fear played a big role for both my husband at the time and myself. He did not want another child, and we arrived at the center, and I remember every detail about this event. This would be something I would never forget. The details related to this day has stayed burned in my memory, unlike other events like taking vacation, surgery. To this day, I can recall every detail. So how is this supposed to be the best solution if the pain still remains? Something sad, depressing, and destructive had replaced the child I terminated. The fear I went in with could not compare to the fear I came out with. I did not feel relief. I did not go out and share about my abortion. Excuse me?
30 seconds left.
Instead, I walked out the back door and knew through and through that I could not undo what I had just done. My life had changed for the worse, not for the better. I did not go out and share with people that I had exercised my right. A week later, I looked 9 months pregnant, and it was estimated that the procedure had gone wrong, and I had to go back in through and go through the whole nightmarish process again while they try to figure out if I had a blood clot and if it would kill me. I know what happens when you walk in the front door, and I know what happens when you walk out the back door, and we're not told, nor are we prepared for what happens to alter our lives going forward and how we will deal with going forward. Divorces,
Time's up.
child fear, abuse, a lot of that ties back to experiences that you don't know in order to cope, and we're not prepared for this. It wasn't until I gone through my own healing and started helping others on their post-abortive healing that I saw this is a simple procedure meant to fix an issue, a procedure that was my choice that changed me forever.
Thank you
I was
very
not
much.
alone, and this is a silent impact that is not really
Thank you for
known
your
about.
testimony. Your time is up. Moving right along, Bob Corcoran. I'm allowing you 2 minutes. If you use less, it would be greatly appreciated.
Thank you, Mr. Chairman. Honorable Chair and members of the committee. Frontier Peace is an association dedicated to advancing libertarian principles in Kansas. Frontier Peace is with libertarian with a little L for the philosophy, not big L for the party. Okay? And we take great satisfaction these days in noticing that peace-loving libertarians are a far more appealing option for people in light of a lot of national events that are going on. On the topic of abortion in today's proposal, many have historically assumed that this is something that libertarians find no justified role for government in. But even at a superficial level, granted that that view really is anarchy as opposed to libertarianism, public polls and positions of national organizations argue against that. There was a 2018 poll that concluded that 58% of libertarians nationwide consider themselves to be pro-life. I think it's fair to conclude that in Kansas, that percentage is even higher. At the party level, both nationally and in the state, there's absolutely no statement on the matter by the party. And there may be any number of reasons for that, but I can tell you what I found within the libertarian community and their discussion is a very rational approach to the issue that I've always found with them, whether it be on theory on the basis of contract law, on property law, or some artificial definition of personhood. It's a very logical method by which they arrive at those conclusions. But undergirding all of this is the non-aggression principle, that we should not initiate force against other people. And that is what really controls our stance on this. The Hodes decision needs to be reversed in the sense that it puts it back into the hands of the legislature to regulate abortion. And I would add that because of the inherently legitimate function of government to protect life and property rights, it's beyond ironic. In fact, it's perverse that of all the issues which our highest court could have championed with natural rights and autonomy, whether it be death penalty, education choice, victimless crimes, asset seizures, you name it, it decided to do so condoning the ending of life. And that's what this constitutional amendment needs to reverse. Thank you.
Thank you. Committee, I'll direct your attention to the agenda. There's additional written testimony from the proponents, Katie Adkins, MD, Kathleen Ahern, RN, Jeff Chaney, Deputy Attorney General, former Governor Jeff Collier, MD, Amy Curry, MD, Lisa Gilbert, MD, Aaron Keeley, Don King, Stacy Peterson, and Molly Price. All of those in their testimony have contact sheets. You'll be able to contact them, email them, and ask any questions that you may have. At this time, I'll open up the question period. Do we have any questions of the proponents? Yes, Representative Miller.
Yes, this is Representative so-and-so. My question is for Brittany Jones. Ms. Jones, the phrase you used a number of times were laws under threat because of HODIs. HODIs has been on the books now for about a year and a half. Are you aware of any district court petitions that have been filed challenging any existing abortion regulations or laws?
Thank you for that question, Representative Miller. There are currently at least 2 cases that are winding their way through the judicial system that are being asked to apply HODIs.
Could I ask for expansion on that answer? What laws are being challenged and when were those cases initiated?
So SB 95, which is the dismemberment case, which is what HODIs was considering, was sent back down to the district court to apply HODIs to the dismemberment case, as well as portions of the Telemedicine Act are under review at the moment.
Where? What jurisdiction? Where's that case?
I know the dismemberment one is in the Shawnee County Court.
No, the second one.
Telemedicine, I believe it's in Sedgwick, but don't quote me on that. The AG would be a better person to answer exactly where those cases are.
Thank you. Representative Heiberger.
Thank you, Mr. Chair. So Representative Heiberger, I have a question for Ms. Kirk.
Are you on?
Yes.
Go ahead.
Ms. Kirk, thank you for your testimony today. In the event that this amendment is passed and that the Roe v. Wade decision is overturned on the federal level, would there be any limit on the ability of this legislature to restrict or ban abortion?
Yeah, let me answer that, but let me first say that Roe being overturned is a huge hypothetical and I think a bit of a red herring. At the time of Casey, everyone thought Roe was going to be overturned because for various reasons in the composition of the court. And, you know, it didn't happen. So that's a big hypothetical. What isn't a hypothetical is HODIs, which exists right here in Kansas. So if right now, if Roe were overturned and abortion regulation, the effect of that would be that abortion regulation would return solely to the province of the states, it wouldn't matter at all. Because HODIs is more extreme and more strict and more protective of abortion than Roe or Casey. On the other hand, if you pass the Value Them Both Amendment and Roe is overturned, then the Kansas legislature would simply be able to pass laws regarding abortion in the same way that it passes all legislation.
Yes, one follow-up.
Sure.
So there will be no restriction on the ability, no limit on the legislature's ability to restrict or ban abortion in that event?
Yeah, so I mean, I think if we're engaging in the kind of extreme hypothetical like Roe being overturned, I think it's hard for me to imagine this body banning abortion. I think the best predictor of what might happen is to look at the sort of laws that this body has passed in the past. And to my knowledge, it has never successfully tried to ban abortion. In fact, Kansas had legal but restricted abortion even before Roe.
Thank you. Representative Woodard. Last question.
Thank you, Mr. Chair. My question is for Jeannie Gowden with Kansans for Life. Thanks. Thank you for being here today. My question has to do with the placement of this ballot initiative, should it pass the House and Senate, on the August of 2022 ballot, rather than August of 2021 or November of either 2021 or 2022. I was just wondering if there was any, if you had any insight into why we would place it on that ballot.
Well, there's, of course, a number of reasons for that, but as we have stated before, all registered voters in the state of Kansas are able to vote in a primary election. And even for those who are not of the two main parties, the Value Them Both Amendment would be on their ballot. As far as having it August 2022, of course, that is what the legislature, through drafting the bill, has determined is when this would be placed, and we are supportive of that. We want to give people who are passionate about the issue of abortion on both sides. We want to give them the opportunity, and they do have that. And I dare say that the same voters who elected all of you, and some of you are on one side of the abortion issue and some are on the other, I dare say that they will come out in August of 2022 and vote regarding this issue.
Seems like we'll definitely need time for people to be educated about this, so I look forward to an amendment to move this to a general election. Thank you, Mr. Chair.
Thank you. Folks, we're going to move right. We're a little behind time. We're going to move to the opponents. First up is former Representative Nancy Lusk. And as I advised you earlier, Nancy, because the opponents did not come together and consolidate their time, each of the 14 will get 2.5 minutes. Thank you. You may proceed.
Thank you. Thank you, Chairman Barker and committee. Thank you for this opportunity. First, I will tell you that I am a believing and church-going Christian, and I do not believe that full personhood can be assigned at the time of conception or soon after, in part because no one knows when a soul enters a fetal body. I acknowledge that my belief is different from many Christians, but I have read the same Bible and studied Scripture and reached a different conclusion. Today, there isn't time for me to explain my rationale, but you can read it in my testimony. I am not alone. There are people of other faiths and other Christians who have a variety of beliefs as to when life officially begins, and our beliefs are as sincerely held and legitimate as any other. By our legal standard of reasonable doubt in the U.S., religious beliefs cannot make the determination of when a zygote becomes a full legal entity. Before imposing restrictions to take away reproductive choice and deny a woman the ability to choose critical health care, government is responsible to prove guilt beyond a reasonable doubt that a life is taken and the crime of murder is committed with an abortion. Some pro-life people argue that scientific proof exists to support their belief that individual personhood begins at conception. On pages 14 through 18, I have outlined my reasoning of why I find their claim of scientific proof not hold up under logical scrutiny. The right of self-defense for pregnant women in medical emergencies must be protected. Abortions in the second half of pregnancies are very rare, less than 1.5%, but they can be absolutely necessary to save a woman's life. There is a great reasonable doubt as to when and if a fetus qualifies for personhood, but here's what we do know. We know with certainty that a woman is a person. When an issue falls into the many unknowns such as this, the power to decide should be left with the individual instead of allowing government to impose its will. Thank you.
Next, we have Mallory Lanner. Did I pronounce that correctly? Is she on? Oh, you're perfect. Again, 2.5 minutes.
Good morning. My name is Mallory Lanier, and I'm a second-year medical student at a 4-year allopathic medical school in Kansas City, Kansas. I have a Bachelor of Science degree in biology from KU and will complete my Doctorate of Medicine in 2023. Upon completion of my training, I hope to serve as a primary care provider in an underserved area. As a future physician of Kansas, I find it necessary to voice my concern regarding this proposed constitutional amendment that would threaten a woman's right to personal autonomy. In medical school, we learn that socioeconomic determinants truly impact one's health, including poverty, education, and access to health care. In addition to completing my studies, I also serve as co-president of the group Medical Students for Choice. I've had the great opportunity to know many Kansas physicians and medical student colleagues through this organization. A peer of mine told me this story that I would like to share with you. As a content warning, this discusses sexual violence and domestic violence. I want to tell you about a patient who I'll call Christina. She was raped very early in her pregnancy by her uncle. Then her husband, who did not believe that she did not solicit the sex, proceeded to severely beat and strangle her. She felt extremely unsafe in her home, and without any money to leave him, she wasn't sure that she was going to survive. Christina was counseled on all of the options she had for her pregnancy in a non-coercive and supportive manner, including abortion. She was given domestic violence resources and referred to social services for further help. Christina is an example of a woman who would be hurt the most by this constitutional amendment. If Kansas were to ever ban abortion, financially privileged women will still be able to travel out of state and receive the health care they need. Poor women will not have this option and as such will be disproportionately affected. The state should not be creating barriers to health care. Instead, we should be making it easier for all Kansans to have access to medical care. I assume that Kansas legislators trust the expertise of physicians working in their state. I believe abortion care is health care. Therefore, I believe that Kansas legislators should respect the physician-patient relationship and allow people of the state the right to reproductive freedom. The amendment has the potential to dangerously harm women and families, especially those already disenfranchised. As a future healthcare provider of this state, I encourage you to strongly oppose this legislation. Thank you for your time.
Thank you. Next up is Megan McQuinn. Welcome to Federal and State Affairs, ma'am. You have 2.5 minutes.
Good afternoon, members of the committee. Thank you for giving me the opportunity to speak today. My name is Megan McQuinn, and I'm a resident born and raised in Wyandotte County. I testified before this committee last year in opposition of the Value them Both Amendment. While the new amendment has updated language, the goal is the same. The amendment seeks to control women and police their bodies. The choice to have an abortion is a very personal choice. I chose to have an abortion when I was 21 years old. I was in an abusive and toxic relationship and became pregnant due to the lies of my partner. However, the reason for my abortion isn't actually relevant today. What is relevant is that I was able to make the right choice for my life and my future. By again attempting to amend the state constitution, you are removing the ability for others to make those same decisions. We should trust women. We should trust that they know what is best for their lives and themselves. We should trust that they don't need a law to tell them what they should or should not do with their body. This amendment is unnecessary as abortion is already well regulated within the state and the nation. The true goal of this amendment is to create the opportunity for the legislature to pass a total ban on abortion. Proponents will disagree with me, yet they have tried time and time again to ban abortion. They have done this through personhood, heartbeat bills, as well as unnecessary and dangerous restrictions on dilation extraction procedures. They have introduced legislation that attempted to make it law for clinics to provide demonstrably false information to its patients about abortion reversal. They have tried every which way to deny women the right of basic bodily autonomy. This is not a newly discovered right, as claimed in the resolution. This is a fundamental right that is granted to all individuals. The Kansas Supreme Court simply rightly affirmed this right. The legislature does not know what is best for women. Women know what is best for themselves. I knew what was best for me at 21. The life I have today is of my own making. The life I have today is the life that I had always wanted. And it is only possible because I had that right to make that choice when I was 21. This is why I oppose this resolution, and I thank you for your time.
Thank you. Next up is Rachel Sweet, Planned Parenthood. Good morning and welcome to Federal and State Affairs.
Mr. Chair, members of the committee. I can do that. Got it. Thank you. My name is Rachel Sweet. I'm the Regional Director of Public Policy and Organizing for Planned Parenthood Great Plains Votes. And we are strongly opposed to HCR 5003 as this legislation aims to remove the constitutional protections for reproductive rights that are guaranteed to all Kansans. Proponents of this bill have downplayed the concerns that are shared by opposing conferees and by many Kansans that this amendment will lead to a total ban on abortion. But we're not fear-mongering and we're not misrepresenting the facts. We're concerned because we can see the writing on the wall. In recent years, numerous states in the Midwest and the South have passed laws banning abortion at as early as 6 weeks, which is before many people know they're pregnant, and they have done so with one goal in mind. It is to overturn Roe v. Wade. And with our nation's highest court stacked firmly in opposition to reproductive rights, their goal is likely to become a reality. And even with Roe in place, states like Kansas have done virtually everything in their power to pass more restrictions on the right to abortion and push access to safe and legal abortion care out of reach for many. In our state, doctors who provide abortion care and the patients who seek it must navigate a complicated web of over 22 medically unnecessary restrictions on the procedure. These laws do nothing to improve patient care. They are simply aimed at making it harder to access. Abortion is a safe and common medical procedure, and it should be regulated as such. The Hodes and Nauser decision leaves ample room for the state legislature to regulate abortion as it would any other type of health care. And if that is the legislature's intent, no constitutional amendment is necessary. What this amendment would do is make it possible for Kansas to do even more to set restrictions on the right to abortion with no regard for a woman's health, whether she has been raped or is a victim of incest. When Roe falls or is eroded beyond our recognition, there will be no legal right to abortion in the state of Kansas if this amendment is passed. Kansas has two paths before us. We can be a state where abortion is safe and legal, or a state where it isn't. This bill sends us down the latter path, and the results will be disastrous. Thank you for your time today.
Thank you. Philip Wood?
Did you say Phil Wood? I'm sorry, did you say Phil Wood?
You have 2.5 minutes.
Thank you, sir. Chairman Barker, members of the committee, thank you for the opportunity to speak with you today. My name is Phil Wood. I'm a professor of psychology at the University of Missouri. I've been a professor there since 1989. I have 2, possibly 3 very brief things to say to you. As a psychologist, I think that it's important that we listen to what the American Psychological Association says about abortion. You can visit their policy statement. I will read just a few of these statements, conclusions from the research there. Women who are denied an abortion are more likely to initially experience higher levels of anxiety, lower life satisfaction, and lower self-esteem than compared with women who do receive an abortion. Experiencing unwanted pregnancies is strongly associated with poor mental health effects for women later in life. There's a strong relationship between unwanted pregnancy and interpersonal violence because the woman is often forced to stay in contact with violent partners. Unwanted pregnancy is associated with deficits to the subsequent child's cognitive, emotional, and social processes, and the number of unsafe abortions is likely to increase when policies limit access to reproductive health care. I am, however, not here to talk about the research from the American Psychological Association. I am a person who has a family who has been through a late-term abortion. In Kansas, there have been 239 abortions conducted at 17 weeks or later. In Missouri, 87 in excess of the 21st week, and 428 in excess of the 17th week. To provide a little bit of a story about this, my wife and I attempted to have another child later in life and sought out frequent fertility treatments. And these resulted in a twin pregnancy, which we were very, very happy to hear about. In my written testimony, you can read how week by week, though, since we had an initial ultrasound and amniocentesis done, the situation changed. We had to go to...
Philip, you have 30 seconds left.
Thank you, ma'am. We had to go to Florida to see if we could have the umbilical cord of one of the twins tied off. And and we then had to seek an abortion with Dr. Tiller in Kansas. He was able to perform the abortion for us. The details of that are in my written testimony. I speak in strong support for the existing Kansas Constitution because I believe that the legislators who drafted that were singularly prescient in the woman's right to autonomy. I'll cede the rest of my time. Thank you.
Thank you, sir. Julie Burkhart, Trust Women.
Good morning.
Good morning.
Thank you, Chairman Barker and members of the committee for hearing my testimony in opposition to Bill 5003. We stand in firm opposition to this. Trust Women is the only provider of both medication and procedural abortions outside the Kansas City area. So therefore, you can imagine that we see people from all over the state of Kansas and beyond. What I find troubling here is that the legislature is trying to insert their will in place of a woman's right to decide in consultation with her family, her faith, and her doctor, whether or not she would have an abortion. It's distressing that legislators would insert their narrow will in place of that of families across the state of Kansas. So we have done a lot of canvassing across door-to-door canvassing across Kansas, both in urban neighborhoods and also in rural communities. We've been talking to your constituents directly about reproductive health care. And I can tell you that there's one common thread that we find. People are relieved to find, no matter what community we are in, that we are there to have an upfront conversation about reproductive health care. And many times, right there on their doorstep, we hear their own private story about their own abortion care that they received. What this amendment would do is that it would pit women against the state of Kansas. It would put the health of Kansas women in danger. And do we really want the state of Kansas to be in the business of putting women in harm's way? Do we want the state to get into the business of jeopardizing the well-being of our moms and our daughters, our sisters, and our friends? I know I certainly do not.
Julie, you have 30 seconds left.
Okay. What I would recommend instead of pursuing this amendment is expanding Medicaid, eradicating maternal and infant mortality, and also working to ensure that contraception is widely available. So even though this intent might be to eradicate abortion from the state of Kansas, we will not be able to do that. Abortion is a part of a woman's reproductive health care, whether it's legal or illegal. Thank you very much.
Thank you. Next, we have Sarah Mayos, I'm guessing, and I think I saw that she was on WebEx.
Yes. And our state organizers organized is one way. Currently, 503. All four communities also. Us have to make first. Create that income books, especially
Sarah, you have 30 seconds left.
urge of young people across they vote especially and city council.
All right, thank you, and I encourage the committee to read her written testimony as well. Next, we have Michael, is it Popa? And via WebEx.
Yes. Good morning. I'm Michael Popa, Executive Director of Mainstream Coalition. Chair Barker and members of the House Committee, thank you for the opportunity to testify in opposition to this harmful amendment. Mainstream Coalition is a nonpartisan organization founded in Kansas 28 years ago by a bipartisan group of sitting legislators and faith leaders to protect the separation of church and state. And in almost all cases, whether or not specifically stated, objections to reproductive rights come from a position informed solely by faith. While we applaud people with strong religious beliefs, we maintain that to best protect the faith traditions of all Kansans, a bright line must be drawn between religious ideology and the act of governing. And to best protect all Kansans, we cannot strip rights legally afforded by the Kansas Constitution. The concerns I bring forward today are shared by Kansans from a range of political and religious identities from across the state. Mainstream Coalition opposes HCR 5003, a dangerous constitutional amendment that would strip an entire population of their constitutional rights to make personal, private, reproductive health decisions. Intensely personal decisions should not be mandated by the legislature nor by strangers at a ballot box. These decisions should be left in the hands of the individuals and families in consultation with their own faith and health professionals. In the event that this makes it onto a ballot, we find the proposed ballot language troubling. It reads in part, the amendment would affirm that there is no Kansas constitutional right to require the government funding of abortion. This statement is misleading because Kansas law does not require government funding of abortion and in fact already bans state dollars from being used toward abortions. Additionally, we oppose the placement of the proposed question on a primary ballot, where voter turnout is significantly lower than in general elections. If this legislature deems it appropriate to determine the rights of Kansans by popular vote, it should be posed to as many Kansas voters as possible on a general election. So today, I call on this committee to protect the rights, dignity, and beliefs of all Kansans by rejecting HRC 5003. And instead, I urge you to support data-driven efforts to reduce abortion rates, like expanding access to preventative health care and contraception and science-based health education. Thank you for your time.
Thank you. Sandy Brown, are you on here in person? Thank you. You have 2.5 minutes.
Thank you, Committee Chair John Barker. Thank you very much, and committee members. My name is Sandy Brown, and I am the Kansas Abortion Fund President. I am here today to urge members of this committee to please vote no on this constitutional amendment that denies the right to reproductive freedom in the Kansas Constitution. Throughout our history of service to Kansans, we have never, ever turned down a person in need. Over the past 2 years, we have funded 755 women who were otherwise unable to afford their abortions. 755 women who couldn't get their procedures even partially paid for through health insurance or Medicaid. 755 people who were only able to exercise the right over their own bodies because they obtained financial assistance. Kansans who simply did not have the cash for a $700 first trimester abortion after paying their rent, their utilities, and feeding and clothing their other kids. We've watched the government erode our access to reproductive health over the past decades, and of course, the heaviest attack has been on Kansans in crisis who don't have anywhere near the financial means to pay for an abortion or even for emergency contraception. With only 4 clinics in Kansas, pregnant people have to travel long distances to obtain medical care, struggle to find child care, miss work, and lose salary. These factors, along with the overarching stress and stigma of abortion, make an already difficult situation much more trying and potentially impossible without prompt assistance. It's marginalized Kansans and their families would be hit hardest if this constitutional amendment passes. Currently, it's lower income folks, often people of color, who frequently cannot afford this theoretically and legally a guaranteed right to all. A long and painful history shows that women will always find a way to terminate their unwanted pregnancies despite the enormous risks involved. And you know that's true. They will always find a way. Let's be clear, Kansans deserve the right to make their own personal, private medical decisions without legislator interference. Our individual constitutional right to make our own decisions concerning our bodies, our health, and our future should never be subject to a vote by legislators with political agendas.
Thank you.
Thank you. Margaret Kramer on WebEx.
Hi, I'm Margaret Kramer. Thank you, Chairman Barker, for this opportunity to testify.
2.5 minutes.
Should government take away the Can you hear me?
Yes. Yes.
Should government take away the freedom to make personal and private life choices? No one could predict the far-reaching effects of the current pandemic. Nor can anyone predict whether a hotter, drier planet with less water may be on the horizon, possibly resulting in food shortages. What if the government then decides there are too many people? The same government that can prohibit women from having abortions can also force them to have abortions. This happened in China, and as the last few weeks have proven, we can no longer state with certainty that something could never happen in the United States. Further, regardless of one's beliefs regarding the religious question of personhood begins, we live in a pluralistic society of many different religious persuasions. The First Amendment states that, quote, Congress shall make no law respecting an establishment of religion, end of quotes. If you want other people to respect your religious convictions, please tolerate theirs. Thank you.
Thank you. Next up is Dr. Mae Winchester on WebEx.
Yes, thank you. My name is Dr. Winchester. I am a board-certified obstetrician gynecologist practicing in Kansas City, Kansas. And I am also a fellow with Physicians for Reproductive Health, which is a nationwide physician-led advocacy organization. Thank you to the committee for allowing us to testify virtually so that we might keep you safe and also keep our patients safe. My work focuses solely on maternal fetal medicine, which is the care of sick moms and sick babies. And just this week alone, I have had patients with severe liver disease, debilitating cardiac conditions, life-threatening blood disorders, and life-threatening preeclampsia, which is a pregnancy-specific disease. This week alone, I also met a very young family who I will call John and Jane. They are pregnant with their first baby, and they were over the moon. Unfortunately, their baby has Patau syndrome, or trisomy 13, and this is a genetic condition that is associated with severe birth defects and significant intellectual disability. The median life expectancy for these babies is about a week, and very, very, very few babies live longer than a year. And when they do, their life is full of ventilators, feeding tubes, and multiple hospital visits. Because of the abnormal pregnancy, maternal complications, including maternal mortality, are also increased. And there is no cure for trisomy 13. When I told John and Jane about this diagnosis, they were heartbroken. Jane sobbed just uncontrollably in that body shaking, gut wrenching way that a mother does when she knows that no matter what she does, she is going to lose her child. And John was sitting next to her, and he held her, and he also had silent tears, and I could tell that he was just beside himself with grief.
Doctor, you have 30 seconds left.
when patients are faced with these impossible decisions that most people in this room will never, ever be faced with, it is my job to counsel non-directional and to provide them with all of their options. And I am just so thankful that all of their options, including abortion, remain legal today in their home state. Abortion is an incredibly personal decision. My patients are incredibly complex and unique, and they do not fit into a one-size-fits-all piece of legislation. And I urge this committee to vote no on HCR 5003 so that my patients are protected. Thank you.
Thank you, Doctor. Next up is Dr. Angela Martin on WebEx.
Yes, good morning.
Good morning. 2.5 minutes, please.
Great. I am also a high-risk obstetrician working in Kansas. I grew up here, went to medical school in the Midwest, went to the East Coast for my medical training, and then I've been back here in practice for about 5 years, and I'm very proud to serve the women and babies of Kansas City. By definition, my career is pro-life. I value moms and I value babies, and my entire career is to try to keep both patients healthy. But unfortunately, there are very complex situations, like just Dr. Winchester highlighted, where women are faced with decisions, and unfortunately, both mom and baby are not healthy. For most of you, your minds are made up on this decision, but I want to highlight another scenario where it might illustrate to you why imposing laws are very dangerous for us as medical professionals. So I will call this patient Jill. She was a mother to 3 children. She was expecting her 4th when she started having vaginal spotting. She came into my ultrasound center for an ultrasound and was diagnosed with a cesarean scar ectopic pregnancy. So this is when the pregnancy inserts into the previous C-section scar in the uterus instead of in the body of the uterus. There is millimeters of tissue protecting that fetus. As the pregnancy grows, the most common outcome is a uterine rupture. When the uterus ruptures, the mom begins to hemorrhage into her abdomen. The last uterine rupture case I had, the mom came to the hospital hypotensive and required 87 units of packed red blood cells. She only survived because she lived close enough to a hospital that could perform massive transfusion. Clearly, cesarean scar ectopic pregnancies are life-threatening. However, at that moment, at 8 weeks, in my ultrasound center, her life is not currently in imminent danger. She is not hemorrhaging yet. I would like to ask the legislatures, even if there's an exemption made to save maternal life, what do I do in this
You have
scenario?
30 seconds left.
Do I call my House of Representatives and ask them if this is enough imminent danger to perform her life-saving abortion? Or do I wait until she presents to me hemorrhaging and try to get her to the operating room as fast as I can to save her life? And if she dies, do we tell her 3 children that the fetus was valued over her life and we could not perform her abortion because we chose to value that fetal life over their mothers? Again, this is just one example. My written testimony has several more to help you understand why laws cannot be made. This is a decision that should be between myself and my patient and her family, and if she chooses her faith leaders. But again, I urge you to read all of our scenarios and all of our written testimonies so you can further really understand the potential effects of laws that are put into place. Thank you for your time.
Thank you, Doctor. And you'll remain on WebEx for questions.
Of course.
Thank you. Next up is Leslie Bush on WebEx. Leslie, are you there?
Yes, I'm here. Can you hear me?
You have 2.5 minutes.
Members of the committee, I implore you to vote no on this amendment and to protect Kansans' right to bodily autonomy. After last week's attempted coup at the nation's capital, I feel even more confident it is necessary to intervene when an extremist few work to undermine the will of the majority. This anti-abortion amendment does not reflect the wishes of Kansans. Indeed, most Kansans, at 54%, support access to abortion. I am one of those Kansans. I've lived in Kansas almost all my life, currently residing in Kansas City, Kansas. I'm a social worker and I'm a community organizer. These restrictive anti-abortion amendments remind me of my work as an advocate for domestic violence survivors. When I worked at a shelter, I fought alongside survivors of intimate partner violence who were seeking safety and justice. In the field of domestic violence, we learn how abusers work to maintain power and control over their victim. Sometimes this power and control is maintained through emotional or physical violence. Sometimes it's maintained through reproductive coercion, which is another one of these tools. Reproductive coercion is the act of controlling an individual's reproductive health choices, such as coercing a partner to have sex without protection or denying access to birth control. This anti-abortion amendment is state-sanctioned reproductive coercion. By undermining the Kansas Supreme Court ruling of 2019 and proposing this amendment, the Kansas Legislature is attempting to assert control and power over the reproductive decisions of millions of Kansans without their consent. I know this amendment is not an abortion ban in its current iteration, but I also know that those who crafted this amendment have made it crystal clear that banning abortion outright is their ultimate goal, and the Kansas Constitution is just the first obstacle in their way. They will not stop until abortion is illegal, putting millions of people who could become pregnant, including me, in bodily danger. Please vote no against this amendment. Voting no means standing with your constituents who elected you to represent their voices. It means standing for reproductive freedom so that people like me who can become pregnant have the ability to make decisions that are best for our families without the government getting in their way. Thank you for your time.
Thank you, and you can remain on for questions. Next up is Elsie Higgins. Are you on WebEx?
Thank you, Chairman Barker. Great, thank you. Thank you, Chairman Barker and members of the committee. I speak to you today as an expert in policy and as someone who helps to facilitate low-income Kansans accessing abortions with the Kansas Abortion. First, I want to talk about how the exceptions in the current resolution are functionally meaningless. Sexual assaults are notoriously underreported. We know that 3 and 4 are never taken to a law agency, which is required for any exceptions to be made to abortion law. In 2017, Kansas paid for only 1 abortion because of rape through Medicaid, and then for less than half of the total cost. Additionally, all Kansas abortion statute currently has an extremely narrow life of the mother exception, indicating being suicidal is not enough to create an exemption to any statute. Recall also that these 2 exemptions named in the constitutional amendment are not themselves. They're references to possible exceptions intended to make this amendment more reasonable. Remember also that in addition to the early abortion bans trending across this region that Rachel Sweet mentioned, Kansas has a legislative finding already passed in 2013 that life begins when an egg is fertilized. Fundamentally, this amendment allows for abortion to be banned in the state following an inevitable reversal of Roe or a remanding of abortion back to. Additionally, abortion is normal and common. It is not an abstract issue that exists only in this hearing or on postcards in primary elections or as a tool to oppose Medicaid expansion. A choice made by about 1 in 4 women on a regular basis. The unintended pregnancy rate in the high at 45%, and out of these pregnancies, about 40% are aborted. People of faith have abortion. 62% identify as Catholic or some other religious affiliation, and over half of people who have abortions have had previous births. Finally, about 636,000 Kansans voted in the primary election, but over 1.8 million voted in the general election in 2020 with record turnout. Having this issue on the primary ballot is fundamentally anti-democratic. So for all of these reasons, I ask you to vote no on the amendment. Thank you.
Thank you. That concludes the testimony. I'm going to go to questions now. Representative Clayton, please.
Thank you, Mr. Chair. My question is for Rachel Sweet, please. All right, so I have a question. I know that other states, you mentioned that other states in the Midwest and in the South have passed similar legislation to this constitutional amendment that we are now considering today. So taking all of the emotion out of it, I would like to hear if there has been any subsequent legislation that states that have passed a similar law have, because I want to see what the path looks like as we move ahead. And I think any red states that you can mention would be ideal, because whenever I put forth legislation, I always consider a red state model, because that's what Kansas is. So tell me what other red states are doing.
Absolutely. So in terms of other states that have passed similar changes to their state constitution, I think Tennessee is probably the best corollary for us. In 2014, voters in Tennessee narrowly passed a similar constitutional amendment at their ballot box. And since then, there have been multiple restrictions passed by the state legislature. Earlier this year in June, or sorry, last year, earlier in June of 2020, the Tennessee legislature passed a 6-week abortion ban.
Thank you. Next up is Representative Carpenter.
Thank you, Mr. Chairman. This is Representative Carpenter. The question is for you, Ms. Sweet. Thank you. Does this amendment preclude the legislature from allowing abortion under any circumstance up until the moment of birth, as the New York legislature has chosen to do?
First of all, I think that's a mischaracterization of the Reproductive Health Act that was passed by New York State Legislature. It allows for a patient to have an abortion procedure after 24 weeks of pregnancy, only in cases of severe fetal anomaly or when a woman's life is at risk.
So all right, may I follow up with another question?
You may.
Thank you. So with the standard of strict scrutiny, as we know that it applies, we've seen other states go through the same standard, and we've seen common sense legislation struck down in those other states. Does that not concern you that that will happen here in the state of Kansas?
No, it frankly doesn't, because I think that any sort of regulation that is purely about patient care would easily meet that standard of judicial review. And as I mentioned in my testimony, facilities and physicians who provide abortion services can be regulated like any other healthcare provider of similar complexity and risk.
Thank you, Mr. Chairman.
Thank you. Representative Hoyt.
Thank you, Mr. Chair. My question is about a term that I've heard used in the testimony today, and I believe now that in this bunch we have Dr. Angela Martin, high-risk OB, so it may be appropriate to help me walk me through this. I've been doing some research on the different procedures that could be considered abortion procedures: medication abortion, aspiration abortion, the DNC, D&E, induction abortion. And I've heard the term live dismemberment used, and my question is that a medical procedure, and of what is live dismemberment?
Who is your question directed to?
Dr. Angela Martin.
Yep.
If she
Yes.
could maybe answer that for me.
Sure. Thank you for the question. That is not a medical term. In no medical textbook have I ever seen that term used. Like you mentioned, there are medical abortions when you are early enough in pregnancy. There are surgical abortions, DNC, dilation and curettage, and D&E, dilation and evacuation, where the cervix is dilated and the pregnancy is removed. Those are the medical terms.
That's all. Thank you, Mr. Chair.
Thank you. Representative Penn.
Thank you, Mr. Chairman. That is loud. Thank you, Mr. Chairman. I have a question for a couple of questions. How about we start with Dr. Mallory Lanier?
Ask your question.
Thank you, sir. Ms. Lanier, the question that I had was concerning, you said that you're a biomedical student, and a paramecium or an amoeba, is that considered life?
Still a medical.
The microphone, please.
I'm still in my training, so I would
defer that question to one of the physicians.
Single-cell organisms, paramecium, and amoebas.
Sorry, could you repeat that?
A paramecium or an amoeba is a single-cell organism. Is that considered life?
Yeah, like I said, I'm still in my training and I would defer.
Thank you so very much. Mr. Chairman, if I may, Ms. Rachel Sweet, please. Ma'am, how are you? Thank you so much for your testimony today and appearing before us. A quick question concerning the median demographics of the areas where abortion facilities are located. Can you give us a little insight into where those are located? We heard testimony that there are 4 in Kansas. Is that what you agree with? If so, where are they located? What's the median income and the demographic racial breakdown?
That's a good question. So yes, there are 4 facilities that provide abortion services in the state of Kansas. There are 2 located in Overland Park and 2 in Wichita. So I don't know off the top of my head the median income of Johnson County, Kansas, or Wichita, but I'd be happy to get that information for you.
We've heard testimony from several today saying that these are located in areas to help out the lower socioeconomic band in Kansas of our constituents. My question to you is, with those 4, the 2 in Overland Park and the 2 down in Wichita, are they located in predominantly white areas or black areas?
Well, our health center in Johnson County, Kansas is located like right off 435 on Row. So I think that's a relatively white area. Wichita, I don't feel like I can as confidently speak to the demographic composition in the neighborhood where our health center is located.
Fantastic. And one quick follow-up, I don't want to take any more time. Dealing with the stats on abortion for 2020, let's just go there. What is the percentage volume and percentage-wise of abortions in the black community?
I don't have that information on hand, but the Kansas Department of Health and Environment publishes abortion statistics for any procedures performed in the state for a given year. So I'd be happy to pull that for you and make sure you have that information.
Thank you. I would really appreciate that. Thank you, Mr. Chairman.
Thank you. Representative Heiberger. Hornberger, I'm sorry.
Sorry, Mr. Chair, I have horrible handwriting. My question is for Rachel Sweet. With HODIs, we're at risk of losing all of our abortion regulations. I call them protections. But in your oral statement, you stated that you wanted abortions to be regulated just like healthcare. So my question to you, with the current regulations we have, which ones do you approve of, and which ones would you like to get rid of?
So I think any regulation that treats an abortion facility like any other facility of its type. So for example, our health center in Johnson County is an ambulatory surgical center, and there are state statutes governing how ambulatory surgical centers should be regulated. I think those are completely reasonable. Things like a state-mandated 24-hour waiting period for patients are not medically necessary. Those don't do anything to improve patient care. So those are the types of restrictions that my organization takes issue with.
Thank you. Representative Smith.
Thank you, Mr. Chair. My question is for Dr. Angela Martin.
Yes.
Go ahead, ask your question.
Dr. Martin, my question is a follow-up to Representative Hoy's question to you and the answer that you gave. I want to be clear about this. It's a two-part question, Chairman, if you don't mind. The first part would be, are fetuses that are aborted sometimes or often alive?
By the time the uterus is evacuated, no.
By the time it's evacuated, which is part of the abortion procedure.
Correct.
Right. And is there times when the fetus has to be, and I apologize for this, but the fetus has to be reduced in size by incision or dissection to be able to be evacuated?
Yes.
Thank you.
In order to remove the pregnancy, yes.
Last question, Representative Potter.
Thank you, Mr. Chair. This is for Rachel Sweet.
Go ahead and ask your question.
In written testimony, you stated that we should value the rights provided by our Constitution. Why are you asking the Kansas Legislature to deny women their right to vote on this amendment?
We believe that people's fundamental rights as provided by the Constitution should not be subject to a popular vote. That is why they are called rights.
You have a follow-up? Thank you. And I'll take one more question if there is one. That was on my list. Yes, go ahead.
Thank you, Mr. Chairman.
State your names as the camera turns towards you.
Yes, thank you, Mr. Chairman. My name is Representative Stephen Howe, representing the 71st District. My question is for Julie Burkhart with Trust Women. I believe she's on WebEx. Does this amendment preclude the legislature from passing laws regarding abortion that allow abortion for victims of rape?
Well, I think that, thank you. I think that it has become abundantly clear, looking at how this unfolded last session and seeing that we are on the same path this session, that the intent is to ensure that even people who have been victims of rape, incest, molestation, might have become pregnant, would not be able to access abortion care and would have to continue those pregnancies if they were only to seek care in the state of Kansas, if I'm understanding your question correctly.
Chairman, may I ask a follow-up question?
No, I'm going to stop you there. We need to evacuate the room here in just a little bit. I've closed questions. Committee, I direct you to the written opponents. There's a long list on your agenda. Representative Heiberger.
Mr. Chair, may I renew my question to the the legislative research that I was not able to have answered earlier?
If it's quick, I've got about 3 minutes to play with. Go ahead, ask your question.
I think it is quick.
Is the research people here? Go ahead and ask your question. We'll see.
Jason, could you tell us the last time that a constitutional amendment was on an August ballot and the circumstances surrounding that, please? Thank you.
And if you don't have that available, please provide it to Representative Heiberger by email or text, whatever. Thank you.
Mr. Chairman?
Yes.
This is Matt Sterling in the advisor's office. I'll have to double check on the last time. I am aware specifically in 1986, 2 constitutional amendments were adopted by the legislature and submitted separately at an election in August.
Thank you.
And Mr. Chair, this is Jordan Milholland. I had previously looked into that for Representative Heiberger, if I might elaborate on his question.
I would rather if you communicate with him by email. We are running over time, and so as to the committee, we're looking at the long written opponents. I also have written opponents or written neutral testimony from Jay Hall of the Kansas Association of Counties. That is all that I have listed. I need to add that my vice chair and I had to play timekeepers today, and if I offended anyone, I would apologize. But because of the pandemic, we have a number of restrictions. The WebEx didn't work at the beginning. We did get all the testimony in. Some of the testimony was shortened because of our time restraints. We did get an additional 30 minutes from the Senate to have this hearing today. This is your reading assignment for the weekend. I think it's 400 or 500 pages. Everything else will be on our web page. Committee, while your colleagues are sitting home this week doing other things, you're going to be sitting hopefully in a comfortable chair reading. You will see this 5003 sometime in the near future. So I would suggest, also we have contact sheets for all of the Proponents and opponents, you can contact them by email. If you have additional questions. With that, I'm not going to open up bill introductions. I hope you have a safe drive home today and a good 3 days off. We will see you on Tuesday. Anything for the good of the committee? Seeing none, we are adjourned.